we're going to hear from Maya. Can you tell us about what your court case is and why it's important to the women all over the world? Why does it matter in terms of gender identity ideology?
My case is a discrimination case under the Equality Act 2010 in the UK, which applies to people in work and as volunteers and as users of services. So mine's a test case about me in employment, but it has implications for women across the UK, mainly women and men, but it's mainly women who feel strongly about this. Losing work, being discriminated in work, being harassed and victimized at work, and being thrown off social media platforms and thrown out of associations and so on. So legally, my case has implications in the UK, but hopefully what happens in the UK will also help what happens in other countries. It supports freedom of association of women in the UK to talk about this stuff and to have the freedom of speech to be able to talk about the conflict of rights between sex and gender identity ideology. And if we can do that in the UK, then hopefully that can help other people around the world.
The judge initially said that the belief in biological sex was not worthy of respect in a democratic society. Can you tell us what that means?
Yeah. So the discrimination case that I brought is about discrimination on the basis of religion or belief. That's the characteristic. You shouldn't lose your job for being a Christian. You shouldn't lose your job for being a Muslim. You shouldn't lose your job for being an atheist. But it also includes non-religious beliefs or philosophies. And because non-religious beliefs don't have the institutional sort of brand name of a religion, they have to have a set of criteria to decide what is a non-religious philosophy that should have the same kind of protection as religion. And the protection that it has is not that your religion has dominance over other people's religion or over other people's rights, but just that people shouldn't be discriminated against because of their belief or their lack of belief. And so there's a set of criteria for a non-religious belief to qualify, which comes from this case called Granger. So it's the Granger criteria, and it's that the belief has to be genuinely held, coherent, important, and about a weighty aspect of your life. So it's like a definition of a belief that is like a religion in that it affects your life. So sort of a belief in string theory probably doesn't count because string theory, isn't going to affect your life, whereas a belief in sex does. And then this final criteria that it has to be not inconsistent with other people's human rights and therefore worthy of respect in a democratic society. And that was the one that in my original tribunal was failed on. It was said that this belief was not worthy of respect in a democratic society. And so that's what we were challenging. And the sort of big legal arguments were that that bar is set very low, because when you're saying that someone shouldn't be discriminated against for their religion, you're not judging the validity of that religion. You're not judging the ethics of that religion. All you're saying is they have a religion. It's important to them. They shouldn't be discriminated against because of it. And so the protection for non-religious belief should be similar. Like things should be treated alike. And so that bar should be very low. And the kinds of things that have failed that test in other cases are things like Holocaust denial and a belief that you should overthrow the government by violent revolution, so things that are really not worthy of respect.
So if we lose this case, or if you lose this case, we're going to be on a par with that. So
right. Well, I mean, that's what. So when I lost the case in the first instance, that's what they were saying, and that's what we're challenging, and so we think that's you know, a pretty strong legal point. And there was quite a lot of discussion about this thing about it's about Article 9 and 10 of the Human Rights Act and the European Convention on Human Rights, which is freedom of speech and freedom of belief, and how they interact with Article 17, which is the one that says none of your rights should be used to take away other people's rights. And so it's the question of your freedom of speech should only be constrained when you're like shouting fire in a crowded theatre, and in the workplace, how much freedom of speech should you have? And clearly in practice in the workplace, you don't have freedom of speech. You know, if you work for Tesco, you're not allowed to go into work and say Sainsbury's is better. You know, you have to say have a nice day. You have to, there's lots of things that you don't have freedom to do at work, but can your employer say you have to say trans women are women? That's the question. Can they require that you either profess to hold a belief that you don't hold, or that they can discriminate against you for a belief that you do hold in sex?
And Maya, I understand that some rather sort of larger institutions or bodies have now supported your case in court. Could you tell us about that? Because
yes,
I found that quite encouraging. I think a little sign of the tide turning, perhaps.
Absolutely. So this was, so the Index on Censorship, which is the NGO that campaigns for freedom of speech, they've been in on the case since quite early on. They requested permission to intervene on the basis of freedom of speech, and they did that, and that was great. But then also surprisingly, quite late in the day, so early in April, the Equality and Human Rights Commission, which is the government's equality body, so their job is to look after everybody's rights and equality, and they've been missing in action on this topic and supportive of gender ideology and not of women, said they wanted to come in, they wanted to intervene, which was a surprise. And initially the judge said no, because it was so late and we only had a day and a half, and it would you know, add to just the time. And then a couple of weeks later, the judge changed his mind and he said yes. So he extended it to 2 days, and the Equality and Human Rights Commission intervened. And what they said was, we had lots of arguments. We had arguments about the definition of sex and what the extent of the Gender Recognition Act on private civilians. And they didn't come in on any of that. They came in on one quite narrowly defined piece, which was that in the original judgment, the judge confused the belief and the manifestation of the belief. So he said that, so what should happen is the judge says the belief is protected. That was the preliminary hearing. And then the next stage is we go back to the employment tribunal and it says, what happened? How did I lose my job? What was it that my employer required of me? How did I act? Were they acting reasonably, or was I acting reasonably? The sort of facts of the manifestation. And the judge conflated the two. So he said that my belief means that I will necessarily misgender and harass somebody in the workplace, and that I will make the workplace a hostile environment, and therefore I shouldn't have any protection. Without any, there's no evidence that I mean, I didn't do that. And I said from the very outset that I would use preferred pronouns. And so the thing that the Equality and Human Rights Commission came in on was just that question, saying, if you put the manifestation aside and you just look at the belief, is it protected? And they said, in their opinion, it is, because, as I said at the beginning, it's a parallel to a religion. And the bar for a religion to be protected is very low. You don't have to judge the validity. You don't have to, you know, it's a very low bar. And so the Equality and Human Rights Commission said, and they were quite careful to sort of distance themselves and say, we're not saying we agree with her, but we're saying she should have the right to hold this belief and not be discriminated against. So that was big.
And that's really encouraging, and it's great your case came up, and I understand we'll hear in the next 2 months the outcome. and most people are reasonably positive, which we'll just continue to keep our fingers crossed. I would also, could you tell us about Sex Matters? You've started an organisation with some other fantastic activists, so that's it's sex. Is it
matters.org,
which is a great organisation. So if you tell us a bit about it.
Yes, and if you were following at all, Sex Matters live tweeted the tribunal, and those are all collected in threads. So it's quite, if you want to catch up on what happened, have a look at Sex Matters.org Twitter. So Sex Matters is a new organisation that I set up with Naomi Cunningham and Rebecca Bull, two lawyers, and Emma Hilton, a scientist, with the aim of clarifying the meaning of sex in law, policy, and culture in the UK. So we're focused on law. So we're focused in the UK across every sector. So education, employment, sport, everywhere that sex matters. We want to clarify that it's sex that matters, not gender identity, and use that to enable people to protect their rights at work and as service users, and the right to freedom of association. Because we think the Equality Act is pretty decent. It protects people from discrimination based on gender reassignment, and it protects based on sex. And if we can clarify that, and if we can use that, and if we can get organizations to see that they've been misadvised about what the law requires of them, there's a lot that can be done without necessarily needing change, but just using the laws that we've got. And so that's what we want to do, to sort of meet Stonewall where they are. So Stonewall's the organisation that's kind of captured. They cover 25% of the UK workforce in terms of advising and telling employers what to do, and that's mainly public sector, charity, big corporate employers. So kind of meeting Stonewall where they are, giving those organisations guidance that is credible and allows them to say, we're not going to do what Stonewall tell us to do.
I think it's such a brilliant development, Sex Matters. And what I know of, I know a few teachers who've been following your case and really, really concerned about it, because it's going to influence what people in all sorts of institutions can talk about. But I think also Sex Matters sounds as if it will be able to get taken up, and those materials will be used in institutions to find a way forward on this, and particularly with your legal expertise, yours and your co-lawyer, but your experience.
Yes.
So it's I think it's going to be a brilliant way forward. Yeah.
And we want to be a sort of we haven't set it up as a overtly feminist organization. It's not political. It's kind of the lowest common denominator that we need to be able to have language and be able to talk about this. And then whether people are coming into it because they're concerned about sport, or because they're concerned about feminism, or because they're concerned about child safeguarding or freedom of speech, everybody, or religious freedoms, everybody needs to have this basic ability to talk about sex clearly, and then people can take it in whichever direction they is most concerning to them. On my website, which is hiremaya.net, there are links to all of the legal documents, so the arguments from my side, the arguments from the other side, and from the Equality and Human Rights Commission and Index on Censorship, and they're a really good resource for people that already want to see what the legal arguments are.